25. A sample essay. Dear Alex, I've now had a chance to read over the essay you sent me. I think if you've had a chance to read the rules for writing essays that I set out in my previous letter, you'll see a number of respects in which your essay could have been better. I've got 3 comments in particular. First, the essay title was the "But for test for causation is neither a necessary nor sufficient test for causation. It should be abandoned." Discuss. You didn't take a clear line on what your response to this title was. Whenever you are given a quote like this to discuss, you have to make up your mind. Are you going to argue that the quote is correct, or that it is incorrect? Instead, what you did was take the line that some people might argue that the "but for" test is an important test for causation, but other people argue that it does not work well in certain situations. In fact, calling that a line is doing it too much credit. It's not a line, it's a fudge. You have to aim for complete clarity in your essays. That is scary, I know. The clearer your position, the easier it is for someone to shoot you down. But this is the game you chose to play when you opted to study law. Remember the first rule of lawyering. Express yourself clearly or die. Secondly, your essay didn't have any headings or anything to break it up. I know you were taught at school to write without using any headings, but it isn't helpful at this level. Using headings makes it easier for your reader to digest and understand what you are saying. And using headings helps you keep your essay on track and discourages you from wandering off into making unhelpful digressions. My third point is that you didn't use your legal knowledge particularly well in the essay. You dwelled far too long on the facts and decisions in particular cases, without any regard for whether that was important for helping along the argument of your essay. But given the fact that your essay didn't have that much of an argument, this was probably understandable. I know it's tempting when you've worked so hard to understand a particular case or set of cases that you would want to show off your knowledge of that case or cases. But you have to resist that temptation like mad. You must subordinate everything to making out the arguments in favor of the basic point you are making in an essay. The art of writing good essays is as much about knowing what to leave out as it is about knowing what to put in. Okay, that's enough about your essay. Here's how I would have approached the essay. I haven't had time to really polish it up. I would have liked to have a few more references to particular legal academics' views in the essay, but it should give you a good idea of how you could and should have approached the essay. But for test for causation is neither a necessary nor sufficient test for causation. It should be abandoned. Discuss. In this essay, I will argue that while the "but for" test for causation that D's tort will only be held to have caused C to suffer a particular loss, if that loss would not have occurred in the way it did, but for D's tort is not a necessary nor sufficient test for causation, it should not be abandoned. The "but for" test in action. Let's begin with a few examples of the "but for" test being used to demonstrate that the defendant's tort did not cause the loss of which the claimant is complaining, with the result that the defendant was not held liable for that loss. In Barnett v. Chelsea and Kensington Hospital Committee, the defendant doctor negligently failed to diagnose that 3 workmen who had turned up to his hospital were suffering from arsenic poisoning, from which they subsequently died. It was held that the defendant's negligence had not caused their deaths. They would have died anyway, even if the fact they were suffering from arsenic poisoning had been diagnosed. In Calvert v. William Hill Limited, the claimant lost a huge amount of money placing bets with the defendant bookmakers. The defendants, having been previously requested to do so by the claimant, had agreed to close down the claimant's bet-making facilities with them, but had failed to do so. It was held that the defendants had owed the claimant a duty of care not to accept his bets, but it was further held that the defendant's breach of that duty of care had not caused him any relevant loss. If he had not been able to place bets with the defendants, he would have placed the same bets with someone else and lost the same amount of money as he did with the defendants. Not necessary. In some cases, the "but for" test does not have to be satisfied before a defendant will be held liable for a particular loss that the claimant has suffered. A. Overdetermination cases. In these types of cases, D1 and D2 have each committed a tort in relation to C, and C has suffered some kind of loss as a result. Each tort would have been sufficient on its own to produce the loss that C has suffered. So each of D1 and D2 can argue that, had I not committed my tort, C would have still suffered the loss that she did. Such an argument will always fail. D1 and D2's individual torts will always be held to have caused C to suffer the loss that she did, and C will be entitled to sue each or both of them in full for compensation for that loss. For example, in Baker v. Willoughby, D1 negligently injured C's leg so that it became practically useless to C. 4 years later, D2 shot C in the same leg in the course of a post office robbery, so that the leg had to be amputated. D1's claim that, had I not negligently injured C's leg, C would have lost the use of his leg 4 years later anyway. So I can't be liable for the loss of the use of the leg for more than the 4 years before it was shot, was rejected by the House of Lords. D1's tort was held to have caused C to lose the use of his leg for the rest of his life, not just for the 4 years before C was shot. I will discuss below whether the overdetermination cases reveal some underlying flaw in the but-for test of causation. But the justice of not applying the but-for case in overdetermination cases is plain. In a case where C has suffered a loss which D1's tort or D2's tort would have been sufficient to produce, it would be obviously unjust to allow each to rely on the other's tort to escape being held liable to C. B. Lack of proof cases. The same sort of consideration led the House of Lords in Fairchild v. Glenhaven Funeral Services to rule that in a case where C contracts mesothelioma in her lungs as a result of being exposed to asbestos by two tortfeasors D1 and D2, but scientific uncertainty makes it impossible to tell which exposure caused the mesothelioma, and makes it impossible even to assess the probabilities that it was D1's rather than D2's exposure which caused it. C will be allowed to sue both D1 and D2 for her mesothelioma. But unlike the overdetermination cases in Barker v. Corus, the House of Lords ruled that D1 and D2's liabilities would be proportionate to the amount of asbestos they exposed C to, so they would be liable on an aliquot rather than in solitum measure. This ruling was overturned, so far as mesothelioma cases were concerned, by the Compensation Act 2006. However, Barker will still apply to any other Fairchild-type cases which do not involve mesothelioma. There is currently a debate over whether, in light of the Supreme Court decision in Cienfueg's Fairchild, does apply to any other cases of uncertainty over causation that do not involve mesothelioma. It is submitted that it does apply in a case like Cook v. Lewis, where two hunters negligently fire towards the same area, and a gamekeeper in that area is hit by one shot, and it is impossible to tell from which hunter's gun the shot came, or to say that it was more likely than not that it came from one hunter than another. In such a case, it is submitted, each hunter will be liable for 50% of the gamekeeper's injuries. The injustice of allowing the gamekeeper to go without a remedy when we know one tortfeasor was responsible for it outweighs the injustice of holding a tortfeasor liable for an injury that he may not have caused at all. Not sufficient. Even in cases where the but-for test is satisfied, a given defendant may still be held not to have caused the claimant to suffer the harm of which the claimant complains. A. No material increase in risk cases. There are situations where the claimant's harm will be merely a coincidental result of the defendant's tort. An example is provided by Chester v. Afshar, where the defendant doctor failed to warn the claimant of the 2% risk of paralysis that was involved in her having a particular operation. That was negligent, and unfortunately for everyone involved, that risk materialized after the claimant's operation. The claimant's paralysis would not have happened but for the doctor's negligence. Had he warned her of the risk, she would have delayed the operation to think it over further, and when she eventually had it, the probability would have been overwhelming that she would not have been paralyzed. However, the paralysis was merely a coincidental result of the defendant's negligence. It was just bad luck that the one time he failed to warn a patient of this risk, the risk materialized. The failure to warn had no effect on the size of the risk. In Chester, all of the law lords agreed that the fact that the defendant's negligence did not materially increase the risk that the claimant would be injured made her claim problematic. The fact that the but-for test was satisfied was not enough to entitle her to recover. However, 3 of the law lords thought that on policy grounds, the normal rule that a merely coincidental result of a defendant's tort will not be held to have been caused by that tort should be set aside. P. Break in the chain of causation. Even if the claimant's loss would not have resulted, but for the defendant's tort, the defendant's tort will still not be held to have caused the loss if something happened after his tort that also contributed to the claimant's loss in such a way that it broke the chain of causation between the defendant's tort and the claimant's loss. For example, if D beats C up so that C is lying unconscious in the street, and T takes advantage of that to steal C's wallet, D's battery will not be held to have caused C to lose his wallet, even though C's wallet would not have been stolen but for D's beating C up. T's deliberate, voluntary, informed, and unreasonable decision to steal C's wallet will have broken the chain of causation between D's battery and the loss of C's wallet. Abandon. But for. The fact that the but-for test is neither a necessary nor sufficient basis for finding that the defendant's tort caused the claimant harm is no reason for abandoning it. The but-for test expresses a fundamental point about why tort law cases give rise to causation issues. If you have committed a tort in relation to C, you have something to answer for and something to make up for. But if your tort has made no difference to C's health or wealth or standing in the community, then you don't have very much to make up for. You might still be required to make some token gesture of regret for the mere fact of committing your tort through paying C nominal or vindicatory damages. But that is all you can be required to do where your tort has made no essential difference to C. It is only where your tort has had an adverse effect on C that C can call you to do more for him, to make up for the consequences of your tort, and put him in roughly the same position as he would have been in had you never committed your tort. Some thinkers on causation would acknowledge this point, but would argue that the but-for test should be abandoned as an inaccurate guide as to when a tort can be said to have made a difference to the position of the victim of that tort. For example, some argue that the but-for test on causation should be replaced with the nest test, according to which D's tort will be held to have caused C to suffer a particular loss, if D's tort was a necessary element in a set of circumstances that were sufficient to bring about the loss that C has suffered. My view is that these calls are misplaced, and that the nest test does not do a better job than the but-for test at identifying in what situations someone's tort can be said to have made a difference to the current position of the victim of that tort. For example, in a case where D1 and D2 independently put poison in C's fish tank, and D1 puts 100 units of poison in the tank, and D2 puts 0.1 units of poison in the tank, and the fish in the tank could only be affected by the poison if more than 60 units were put in the tank. The nest test implies that D2's putting poison in the tank has caused C's fish to be poisoned, as there is a set of circumstances D1's putting 59.9 units in the tank, and D2's putting 0.1 units in the tank where D2's putting 0.1 units of poison in the tank would have been sufficient and necessary to bring about the result that C's fish were poisoned. This seems wrong. D2 did wrong by putting poison in the tank, but his wrong had no effect on C. As a result, D2 does not have anywhere near as much to make up for with C than D1 does. The but-for test recognizes that, but the nest test does not. Have you ever heard the story about Michelangelo and the angel? One of Michelangelo's friends was admiring a sculpture of an angel that Michelangelo had carved, and asked Michelangelo what was his secret for creating such an amazingly lifelike sculpture. Michelangelo replied, "I saw the angel inside the block of marble, and I carved until I set him free." For me, that story expresses an important lesson about writing essays. A great essay will make you feel like it was just waiting to be written. All the author did was serve as a channel for getting that essay out of the ether and down onto paper. You should aim in your essays to try to achieve the kind of naturalness and flow and inevitability that will make the reader think. It never could be any other way, which are the final words on the Beatles' Sgt. Pepper album. Whenever your essay starts getting really gnarly and complicated, stop and think, what am I doing wrong here? Because you are doing something wrong. You just have to put your finger on it and stop doing it and get back to writing something clearer, simpler, and cleaner. All this talk about essays makes me think that it might be an idea to give you some tips on writing dissertations. A lot of universities now make their students write dissertations as part of their course, or at least give their students the option of doing one of their papers in the form of a dissertation. The trouble is, I've never written a dissertation in my life. But I know a guy who has, and he'll be able to give you some tips. In the meantime, I'll think about what advice I could give you on answering problem questions, the other main type of question, other than essay questions, that you will be expected to answer in your exams. All best wishes, Nick.